I'm Nikki Jovicic from LookUpStrata and also the Managing Director of Tower Body Corporate, a body corporate management company in Queensland. I'm your host for today's session. Today we're exploring the F word and what it means in relation to strata managers. No doubt this will be a thought-provoking session. Fiduciary describes a unique relationship of trust and confidence, typically between parties with asymmetric power. You probably deal with your fiduciaries regularly, although you may not know it. Does this law apply to strata managers? And if so, what are the implications and what does that mean for you? Before we begin, as always, I'd like to mention that the information in this session, including discussions arising from submitted questions and also chat, is not legal advice and should not be relied upon as legal advice, and you should seek independent advice before acting on the information contained in the session. So yeah, we're happy to welcome Michael Kleinschmidt back today. Michael is a partner at Bugden Allen Lawyers. He has specialised in strata law for over 20 years, and during this time he served all the peak stakeholder groups and acted for almost all the different stakeholder groups in almost every conceivable strata matter type. Michael is also thankfully a LookUpStrata regular and responding to Queensland questions and joining us for interesting webinars over the years, ranging from short-term letting, how not to pinch other people's land, and approval for solar panels, not to mention the recent session on insurance commissions a few weeks ago. So thanks for agreeing to come back today, Michael, and explore this really interesting topic in a bit more detail.
Thanks very much, Nikki, and thank you to LookUpStrata for the opportunity to come back and have a chat about it. Like most F words, fiduciaries is not really spoken about very much, and I think there's a fairly low awareness of the law in this area. In the lead up to this presentation today, it's clear to me that in talking to quite a lot of strata managers, body corporate managers that I have relationships with, that it's one of those things that doesn't really pop up on the radar. If it does, there's usually a phone a friend to a lawyer that they know and trust. And, there's a quick conversation. I do strongly recommend that it's part of any compliance plan for the operation of a business. And I do really recommend to SCA, nationally and across all the states, to go back and revisit this topic and have a really good hard think about it. Why? Well, we'll dig into that in a minute. So look, the first thing is we have to understand what the fiduciary relationship is. Now, Nikki, everybody can see my screen, presentation screen.
It hasn't popped up yet, Michael. Sorry, if you can just share that again. Here we go. But, yeah, that looks good. Thank you.
All good? Right,
yes.
Yeah. Okay, ladies and gents. So first of all, we need to identify if there's a fiduciary relationship. So what are they? Well, typically they're a relationship where a person is bound to act for another person's benefit, like a trustee and a beneficiary, all right? A lot of you might have family trusts, discretionary trusts, those sorts of things, so you understand what that relationship is. It's also a relationship of trust and confidence. As a lawyer, I can't act for you as a client if you don't trust me. And over the years, once or twice, when it's become evident that people don't trust me for some reason, I've had to terminate that relationship because it doesn't work unless there's trust and confidence in the person that you've engaged. So a solicitor and client relationship is a fiduciary relationship. There's an expectation that your fiduciary is going to act for your benefit and not another person's benefit. So when you go see your doctor as a patient, you expect that they're going to give you health advice which suits your circumstances and is best for you, as opposed to the pharmaceutical company who is going to send them on a golfing holiday. So that's the sort of relationship that you expect. Now, there's a list of these relationships talked about in case law. It's not a closed list. It can be expanded from time to time. And that list has developed over literally, a couple of 100 years. Not that long ago in New South Wales, another relationship was added to the list, and that comes out of the Arrow asset management case, where a developer was found to be a fiduciary of the body corporate that they were setting up as part of a brand new development. And that meant that they had an obligation to the body corporate, which hadn't yet come into existence, but they were a fiduciary with that body corporate. And the way that items are added to this list is usually because you go looking for common features in the other relationships. The judges do, and then they say, well, there's a lot of these common features, So we're going to find that a fiduciary relationship exists. All right. Now, if there is a fiduciary relationship, then you end up with these fiduciary duties. And fiduciary duties are proscriptive. So you're not allowed to do certain things. And they're not prescriptive. You must do certain things. So it's a prohibition on doing certain things as opposed to you positively having to do certain things. And that's an important distinction. For example, a lot of people misunderstand this law by saying that you have a positive duty to act in if you're a fiduciary, you have a positive duty to act in the best interest of the person that you're a fiduciary for, the beneficiary. That's not true. Sometimes that's added by statute, such as body corporate managers in Queensland, and I'll circle back to that in a minute. But they're proscriptive and not prescriptive duties. So the three duties I'm going to talk about, and these are the widely accepted ones, by the way. It's the conflicts rule, where a fiduciary should not be or place themselves in a position of conflict, whether between duties or between a duty and an interest. So duties might be duties that you owe to two different clients. Duty and an interest might be a duty that you owe to a client and your own self-interest. The next rule is the purchasing rule. And so a fiduciary may not buy from or sell to their beneficiary property over which the fiduciary obligation extends, unless both the fiduciary relationship is founded on terms which give the fiduciary the right to sell or buy, and full value is given after informed consent is received from the person to whom the fiduciary obligations are owed. Now, it's pretty technical. It's a bit of a mouthful, but a good example is company promoters. You know, they're setting up a new company to go and develop a piece of new technology. They own all the shares, or they own the rights to issue the shares. They're out there flogging off the shares and promoting the company. So you've got to give full information to be able to get informed consent. And the whole nature of the relationship is, I'm a company promoter, so I'm flogging off shares in this new company. That's how our relationship is going to come into existence. Next, and the third rule is that fiduciaries cannot use their position, and by virtue of it, to obtain a profit, benefit, or other advantage without full informed consent of the beneficiary. So this is the one that does cover things like insurance commissions, but I'm not really going to focus just on insurance commissions today. It's just one of the wide array of different activities that I hope to be able to talk about. And there's some pretty specific examples on that one later on. So now that we know what those duties are, the next question that arises is, well, look, are strata managers fiduciaries? And my answer to that question is yes, okay? There's a lot of parallels between a body corporate manager, strata manager relationship with their body corporate and a number of other recognised classes of fiduciary relationship. So director and company, in Queensland, for example, as a strata manager sits on the committee as a non-voting member of the body corporate on the committee. Agent and principal. So where a body corporate manager is out there binding the body corporate to contracts with third-party suppliers, then they're acting as an agent, and they do that all the time. Trustee and beneficiary. You know, when a body corporate manager is hanging on to funds on behalf of the body corporate and managing those funds and authorising or transacting on the accounts. So look, the net result is, and indeed there's a New South Wales decision, which we'll talk about a bit more in the questions, that make it pretty clear that at least in New South Wales, it's definitely a fiduciary relationship. And even though I'm not aware of a case in Queensland that's right on point, I'm prepared to bet a very nice bottle of red wine that it is the case. So the long and the short of it is that it's hard to avoid being a fiduciary as a strata manager unless you pare away all the things that you do as a strata manager down to things like just being a mere keeper of the records. Now, in this regard, I have to thank my partner, Gary Bugden, whose paper from the Australian College of Strata Lawyers I have relied upon in preparation of this presentation today. It's a wonderful paper where he explores this in some detail. I will ask his permission nicely to see if we can distribute it. It is an ACSL paper, so usually it's only available to members, but we'll see. Gary is very much in favour of education of stakeholders in the sector. So the next thing is, are the fiduciary duties owed to the body corporate? So if you're a strata manager, who do you owe those duties to? Do you owe them to the lot owners? No, you don't. You owe them to the body corporate. And that's an important point, because the person who is owed the duties is the person who can bring a claim in respect of a breach of them. Can the fiduciary duties be influenced by contract? Well, yes, they can. So as a strata managing agent or a body corporate manager, you have a contract with your body corporate. Does that contract supersede the law of fiduciaries? Well, the law of fiduciaries and the law of contract coexist together, and they have done for a very long time. In fact, there's quite a lot of cases that speak to the fact that they do coexist, and indeed some fiduciary relationships couldn't arise in the first place without contract law. So the point of the story here is that, yes, a contract or a contract clause might permit something to occur which is otherwise a breach of fiduciary duties. However, the contract in question or the clause in question must very clearly displace the law of fiduciaries to do so. And there is a 30-year-old case from New South Wales that I suspect a lot of strata managers and maybe one or two peak stakeholder groups have filed away. We're okay on this area of the law because that case, the Alliance case, means we can do what we're doing. No is the answer to that from my point of view. If I was a strata manager and I saw some of the practices going on today, I would not be relying on that case to get me out of the hot water. And we'll talk about that more in questions. So the next question is, can the fiduciary duties be influenced by statute? Well, yes, they can. And again, there's this coexistence between the two things. You know, the question with statute is always things like, is the statute or the piece of legislation intended to be a code that displaces all of the other law that can exist, you know, common law, equity, the law of fiduciaries. A statute, and most of the time they're not intended to do that, by the way. Most of the time they actually sit with the rest of the law, which is why you have funny cases going on, you know, to do with like the Arrow Asset Management case in New South Wales, you know, where there's a fiduciary claim, even though there's some law around the establishment of community title schemes and strata schemes. So statutes might permit what would otherwise be a breach. However, again, you've got to look at whether or not they displace the law in its entirety or they just supplement it or take away a little part of it. And we'll come to that when we talk about disclosure. So the next question is, well, what if there's a breach? What if there's a breach of this law? Well, the first thing you've got to ask is, did the breach take place within the period of the relationship? Now, that's pretty obvious when you have a body corporate manager, strata managing agent, where they have a contract term and the contract term starts and the contract term finishes. And, you know, if the breach takes place during the middle of the contract, it's a pretty easy question to answer. It's less obvious, however, when the body corporate doesn't exist yet, or the body corporate isn't a client yet. So that's another question that you've got to look at. So in circumstances where the body corporate doesn't exist yet, you'd have a lot of people out there saying, well, that's okay, I'm not going to owe duties to them because it doesn't even exist. Well, I've already mentioned company promoters. So company promoters will get out there and drum up all the capital required to kick off a new venture. And oftentimes the company doesn't exist when they're doing that. Doesn't exist yet when they're doing that. Well, there's a pretty solid body of law in relation to company promoters being fiduciaries. And of course, in our Corporations Act, some of those principles have been reflected and expanded upon and or modified so that those principles are black and white and very obvious to people who take the time to read the Corporations Act. That law in relation to company promoters has then been applied, you know, in effect with respect to developers who are creating and selling lots off the plan. So those developers have fiduciary relationships with the bodies corporate that they are going to bring into existence. So that's an interesting one. One of the ones that I find interesting and maybe one day I'll get a chance to have a good solid look at is where a body corporate manager is pitching for work with a body corporate, goes through the process of handing over their draft agreement, and you know, does the fiduciary relationship exist at that point in time between the two of them? There's definitely issues around disclosure. I think there's some significant issues around disclosure of terms and conditions in body corporate managers agreements that should be addressed. And with respect to insurance commissions, John Trowbridge has spoken about that. But I think there's some other ones that need to be addressed too. And one little bite for most people that are watching is please hang on until the end, because I'm going to make a bit of a promise to you, and I'm going to give you something that you can take away and use for your benefit, whether you're a lot owner, a committee member, or a strata managing agent, body corporate manager. There's a couple of freebies at the end that I hope you find useful. So the next thing is, well, what's the effect of disclosure? Because everybody uses the D word to combat the F word. Full and frank disclosure is part of a defence to a breach in some circumstances. It doesn't stop a breach. By the time you get to the point where you're needing disclosure, you know that you're going to be in breach, and it's only part of the defence. Disclosure is a necessary precondition to fully informed consent. You can't have your beneficiary consenting to the breach unless they know everything they need to know to make an informed decision. Now, if you're the only person that has that information and you're being niggardly with the amount of information that you provide because you're afraid of the consequences or that you're not going to get the work and all the rest of it, you can find yourself in real trouble. So it's a necessary precondition. But the other half of the defence is that informed consent. And there's plenty of cases, plenty of law, that informed consent can sometimes take things like independent legal or financial advice from third parties before a person in a vulnerable situation or relying upon their fiduciary can make an informed decision. I will quite often in my legal practice, when I'm proposing to do some work, I will say in scopes of work and fee proposal, consider that you might need to take advice from this person, or this person before you decide whether to engage me to do this work, because you need that to be able to make an informed decision. So disclosure as a defence too can work in respect of the no profits and the purchasing rule. So I can't make a profit from my position, using my position without your informed consent, and also the purchasing rule, which is buying and selling, to or from your beneficiary. Do you know what? It doesn't work in relation to the conflicts rule, right? A conflict between duty and duty and duty and interest, because it just can't fix things. In those situations, you have something which is pretty much irremediable. And I'll give you an example of that a little bit later on, in terms of a conflict between two duties owed to two different clients. So if there is a breach and there's no defence, what are the remedies? So in this case, we're talking about bodies corporate. So what are the remedies available to a body corporate? Well, they can ask for an account for profits, which is hand over the profits to me you made because of your breach. They can also ask in the alternate, so these two things are alternatives, for equitable damages, which is give me money to put me in a position as if your breach never occurred. All right. So they sound the same, but they're not. There's an important difference between the two. The profits rule takes into account the work that the body corporate manager does, during the process of the breach, which would be relevant particularly to things like insurance commissions. Whereas the equitable damages rule puts you in a position as if you had really good, fully informed consent. There was another provider. They had a different arrangement that was going to cost you less ultimately. And when I say cost you less, including sneaky bait and switch pricing, here's my low headline price, and then there's all the plus, right? So that equitable damages relief is about putting you in a position as if the breach had never occurred by effectively going with a third-party supplier. So you could have got it cheaper, okay? There's actually a really important appeal going on in Queensland at the moment about this, which my firm is involved in, one of my partners is handling, where a developer off the plan was able to buy caretaking services for the body corporate at literally half the price as was put into the caretaking agreement, which the body corporate was then bound to accept. And we argued that there was a breach of fiduciary duties, along with a breach of statute and a number of other things. Now, that's under appeal. I won't say too much about it, but there's another practical application of that issue of equitable damages, because if you can go out and buy the same services on the market for 50%, then surely your damages should be equal to that difference between the two things. Now, this is where we start to have some real fun. So, wow, I didn't know that. I find it fun. So the first thing is, with respect to disclosure legislation, most states have legislation regarding disclosure. In Queensland, that includes commission arrangements for insurance commissions specifically, and then also relationship and benefit disclosure. So body corporate's going to, buy some painting services. Well, he's my brother-in-law. So body corporate, you need to know that. Or he's going to pay me 5% of the contract price. You need to know that, okay? So in Queensland, we have a wonderful set of provisions to do with associate relationships, where if there's an association between two people, including as a series of steps, you've got to disclose as well. That's really good at combating structures that are used by people to try and hide these benefits. My cousin's sister's brother's aunt has a unit in a unit trust and the company director is me, and that relationship of association means that they still have to disclose under those provisions. So in those cases where the body corporate manager is going to take a benefit, then disclosure is mandated. And if you don't disclose, then there's an offence, right? Now, here's the tricky bit. This is the wow, I did not know that bit. That provision doesn't necessarily mean that you can keep the benefit. All it says is that you've got to disclose the fact that it's proposed. Now, in my view, and I want to run a test case on it, it doesn't necessarily get rid of the law of fiduciaries in this respect. And there is disclosure, and then there's disclosure, okay? Some of the disclosure that I've seen is absolutely pitiful, and it doesn't put a body corporate in a position where they actually know what they need to know to give informed consent. So it is entirely possible that you can satisfy your statutory obligation by effecting disclosure and then be caught on the fiduciary side of things by not obtaining fully informed consent. So two different things. So if I was a body corporate manager in Queensland, I'd be getting some legal advice about that, and I would get serious about my disclosure and not pay lip service and say, well, I've effected disclosure, so I'm not going to get prosecuted, so I'm okay, and I can take that benefit, all right? So the next one is you're going to the big house, people. There's two offences in Queensland under the criminal code, specifically in relation to this stuff. Like if there is corrupt receipt or solicitation of valuable consideration as an inducement or reward, where the receipt or expectation is to influence a particular outcome, then you can be charged, you can be convicted and go to jail for up to 7 years. What is that provision about? You take money to direct work without disclosure or consent. All right? So forget about the Body Corporate Community Management Act for a moment, giving disclosure. If you are taking a kickback, and I'm going to preface this by saying, I love the strata sector. I love, the people that work within it. They are hardworking, underappreciated, and often underpaid. And there are a lot of really good body corporate managers and strata managing agents out there who do their absolute best to look after their clients. And I've got a lot of time and a lot of respect for them. In fact, that's why I spend my time doing what I'm doing now, because I want to support them. What troubles me is that sometimes there's a lack of awareness. So you have good intentions, but bad execution because people aren't aware. Or you've got what I call sociopathic behavior, where people are aware, but they just don't care because they're more interested in just getting the work done and getting the money through the door. And then you've got legitimately bad actors who will just set out to do the wrong thing to make as much money as possible without regard to compliance. So they're the sort of people that I'm talking about now. I'm not talking about your average body corporate manager out there slogging away in the trenches, doing the best they can in the circumstances that they're in. and more often than not doing a fabulous job, right? So these sort of criminal provisions are for the people who literally will say, you know, I'll push all of my body corporate plumbing work over to you if you pay me a kickback. Okay, that's the sort of thing we're talking about. Now, the other criminal provision here is it flips around. If you give money to direct work without disclosure or consent, you're also committing an offence. All right. So that's just a little taste of the fact that some of these behaviours and practices aren't just about looking in one area of the law or one area of a statute and saying, I've got a tick here, so I've got a tick everywhere. That's where you need a lawyer or a law firm with broad experience who can say, we've done a bit of crime, or we've got an associate who does crime. Let's have a look at this as well. And it usually comes down to looking at new practices that you're thinking of adopting and saying, is this a good thing? What does this amount to? And a good idea is follow the money. Who's getting money for doing what? That's a good start, right? Which brings me to risky business. Unfortunately, some common and becoming increasingly common business practices can be breaches, even though they involve intermediaries or indirect benefits. And by breaches, I mean of fiduciary duties. Risk mitigation is possible, but ethical behaviour is better. Risk management is not ethical behaviour, okay? Professionals act ethically. Business people use risk management. Now, you can be both, but if you're going to be a profession, then you've got to act professionally. So the classic example here is freebies or discounts. Hey, come on over and do the plumbing at in my office for free, and then I'll let you quote for my body's corporate. All right? That's a bit risky, isn't it? Hey, developer, I'll set up your body corporate for free with development consulting services for you. I've got a great team that does it. And all you've got to do, don't pay me anything, just give me the first 3-year term for that body corporate management. And we've got a question about that in the questions I see. Another one that I love is training days and CPD. Hey, look, come and pay for my training day down at the Versace Hotel. You're the only supplier in this area that we're going to talk to. And if you do that, you're going to be our exclusive referrer for this sort of work. All right. So the business is taking a benefit because it's got a staff training day. You know, and typically I look, these are not instances that I have made up, by the way. Because of my interest in ethics and ethical behaviour and the presentations that I've given and sitting on the you know, the ethics committee for SCA Queensland, and I'm not breaching confidentiality in any way, by the way there. These are real life examples where I've had friends and colleagues and other places, and I'm aware of these things. So I have not made these up, by the way, they are real. So training days or CPD, you know, and the most innocuous one is, look, come and provide in-house CPD for my staff and we'll refer you work, all right? Now, I go and provide in-house CPD for staff, but the moment someone says to me, and I'll refer you work, I say, stop, you send me work because I do a good job. You don't send me work because I come over here and volunteer my time, all right? And I'm not going to have it any other way, okay? And there's a difference. It might sound a little bit sanctimonious, and that's not how it's intended, but that's how this law works. So next thing we're going to move on to is what I call trends, truths, toxins, and thoughts. Some trends that I see, dangerous trends. Horizontal integration and dollars per client. So strata management is usually a high volume, low margin business model, right? There's low headline rates. I'm only going to charge a couple of $100 per lot per annum. And then that wins the business. And then typically you've got hourly rate charges or hidden income coming in somewhere else. Now, I'm not saying that hourly rate charges are bad. Okay, that's what we do. We're forced to do that because there's no other business model that really works for us as lawyers. But there's got to be adequate disclosure of that. And most of the time there is adequate disclosure of hourly rates, etc. But, you know, the old bait and switch where you turn around and say lowest management fees ever, you get into the contract and then lo and behold, there's plus, 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 plus. That's not a great business practice from a consumer point of view. One of the trends here, though, is horizontal integration. What we want to do is get more dollars per body corporate per annum so that we can then grow our business or be more profitable. And horizontal integration, for those of you that don't know, is all about taking allied or associated areas that provide services to body corporates and trying to be a part owner or an owner of them as well. So things like strata managers or body corporate managers becoming part owners of insurance brokerages, utility suppliers, utility billing services, and maintenance companies. Now, that's a trend, okay? But hey, make sure you do your compliance planning, because as a strata manager, if you're a fiduciary and you've already got statutory disclosure obligations, but you put, add to that the fiduciary element, then you're going to be disclosing a lot, okay? You're going to be saying to people, by the way, I also am a part owner of this insurance brokerage and this utility service provider. I do receive a benefit from that. The amount of benefit that I receive is typically calculated in this way, boom, boom, boom. That's a benefit for you because I can, there are efficiencies or whatever, but you hang out the dirty laundry so that people can see it, and then they can compare apples with apples. So if I go with firm X and this is what they do, if I go with firm Y with A, B, and C, am I better off or worse off? That's the whole point. The next one is a truth. It's a very uncomfortable truth, but it's about time it was said. I've been seeing this for many years, and it's about what I call upselling and onboarding. In the provision of legal services, I see that where a third party pays the bill, then the service is upsold. Now, I apologise to my listeners from other states, but there's two really good examples of this in Queensland. Debt recovery of body corporate levies and consent to assignment of management rights. Now, in both of those situations, the body corporate's legal costs are paid for by a third party, right? In a debt recovery matter, ultimately they're paid for by the debtor because of our debt recovery provisions, in effect. There's a little bit of a loss of leakage, but that's pretty much it. Body corporate's legal costs when there's a consent to an assignment of management rights, same sort of situation. Usually it's the outgoing management rights operator who pays the body corporate's reasonable legal costs. It is almost universally true that where that happens, the fees that are being charged are much higher than they need to be. And I have seen and I am aware of relationships where that happens in exchange for onboarding, okay? What do I mean by onboarding? I'll send you, for example, my debt recovery work if you send me all of your developers, so that I can then, I'll onboard more body corporate clients and I'll give you all of my debt recovery work. Now, let me be clear about that. I see that as a dangerous business practice. I haven't had time to drill into, would it breach this fiduciary relationship side of things? Probably would. But it's definitely something that I am seeing, and it's definitely something that I think needs to be disclosed so that people are aware of it. Because if you put those two things together, then what you get is a bad result for everybody, right? It's just not a good outcome. It's not a good outcome for relationships inside the body corporate. It's just bad. Righto. Next one is a toxin, commissions as a cancer. I see commissions as a cancer, I really do. The historical accident of strata managers helping with insurance was retained in the legislation in Queensland by mandating disclosure of commissions. Over time, this is just my view, over time, disclosure has become entitlement. Entitlement has now moved past that has moved past expectation and into exploitation. With more disclosure provisions in the 2020 regulation modules in Queensland, the irony is that the same thinking is being applied. And that thinking is, if we disclose the 5% commission that we're proposing to take on every maintenance contract that the body corporate enters into, then that's okay. And we're entitled to that 5%, right? It's the same thinking that arises out of the insurance disclosure. Oh, if I disclose that I'm going to take 15 to 20% of the insurance commission, that's okay, it makes it all right. So I'm going to do the same thing with this maintenance contract stuff, all right? From my point of view, it's a cancer and it needs to be cut out because it's leading to bad perceptions about the sector and the industry. And why? Because we've got a cost of living crisis and everybody's looking at their strata levies. I mean, 2 days ago, a day ago, I was down in Brisbane and on the way down doing a presentation for some new management rights operators. And on the way down, I was listening to Radio National with the Deputy President of SCA National talking about body corporate managers' fees and body corporate levies, with a self-managed scheme from Victoria. There is a lot of focus coming in on this now because we're all suffering from the cost of living crisis. So some stones are going to be overturned. And if I was a body corporate manager, my recommendation to you is turn those stones over now. Make sure you're checking under those rocks. Make sure that you are clean and that you are happy and comfortable. You know, your best indicator is your conscience. Unless you're part of that 3 or 4% of the population that's a sociopath, then your best indicator is going to be your conscience. Do I feel comfortable about this? Thoughts. Professionals act professionally. True professionals are trained in their ethical and fiduciary duties. And there's an overlap. They're not exactly the same thing, but there's an overlap, okay? And they keep themselves up to date. They avoid not only breaches of their fiduciary duties, but they avoid even the perception of a breach of fiduciary duty, okay? Because then you protect and enhance the reputation of your profession. I have said no to more than 100 legal jobs by now because of the mere perception of a conflict of interest or a conflict of duties arising, just the mere perception. And in that regard, I'll pose a question to the strata managers that are watching. If you were acting for 2 community title schemes, 2 owners corporations that were situated side by side, and they were having a dispute about a boundary fence or subsidence, would you give up one of those body corporates or the other, or both? As a lawyer, I have to give up both of them. All right, I have to give up both of them. I can try and erect a Chinese wall between one manager and another manager so that they're not talking to each other and sharing information and all the rest of it. But you know what? I don't do that. You know, we stop acting for both if that ever happens. Have a think about that. So, the pledge. If you're like me, you'd be mad as hell about a lot of this, particularly if you're a body corporate or a lot owner, or you're one of those body corporate managers or strata managers out there who does act ethically and does do the right thing. You would be bloody furious about these other people that are doing this stuff, dragging your name, you know, your profession through the mud with these sort of activities. So there are some things that you can do. In about March this year, my partners and I were having a discussion about exactly this. And at the moment, this is what we are discussing, putting on every single fee proposal and scope of works that we give to a body corporate. Hasn't been approved yet, but this is the working draft. Bugden Allen Lawyers supports the strata sector through volunteer work for and sponsorship of peak stakeholders and educators. We never offer or pay commissions to strata managers, their associates or others in exchange for the privilege of providing legal services to you. Now, if I have my way, that'll probably end up in our client agreement. So it actually becomes a clause of our client agreement. So we don't play this game. We don't sit there and give kickbacks to get the work. And what I'm saying is take that paragraph. If you're a lot owner or a committee member or a body corporate, take that paragraph and look for it. Or if you're asking for quotes, ask your strata manager to insist that that goes into the quote so that you know when you're comparing quotes, you can actually compare what you can see as opposed to the things that you're not seeing that are in the background that aren't being disclosed to you. Part 2, look for this from your strata manager before you engage them. All right? Secret commissions or benefits are a serious problem in the strata sector. Some strata managers, directly or through associates, receive commissions or other benefits from body corporate suppliers. We never ask for or accept, directly or indirectly, commissions or other benefits from body corporate suppliers. I throw down the challenge to SCA across the country to adopt this. I challenge them right now to adopt it. That promise is part of our contract with you. See clause X. So it's an enforceable promise. It becomes a warranty under the contract. Before deciding whether to engage us or somebody else as your strata manager, we recommend that you ask our competitors for the same promise and for it to be included in our contract. All right? Overnight, a lot of the stuff that I hear about from my friends and colleagues and clients and others who reach out to me about this stuff, overnight, a large slab of it would disappear because people wouldn't be able to make this promise. Okay. Now I know, again, I don't want to offend the strata managers that are out there that are in the trenches, slogging away, doing a great job. You people, there is nothing for you to lose by saying this, right? Nothing for you to lose, but there's everything to gain, because you're going to start to show up those people in the sector who are doing the wrong thing. Part 3. Test cases, ladies and gents. Send me some stuff. What I want to do is ask you now for to refer to me or to your favourite lawyer. It doesn't have to be me, but I'm interested in the area. I'm actively looking for test cases. And the way I put it there, and my apologies to Dire Straits, is that's the way you do it. The first sort of test case that I'm looking for is where a strata manager, body corporate manager, offers free consultancy services to a developer, valuable consultancy services to set up a body corporate for free in exchange for the first 3-year term of the, or 1-year term, or however long it is, being granted to them. All right. Now, I'm not coming after the strata manager, I'm coming after the developer. And the ideal situation there is for the developer still to exist. So there's not a special purpose vehicle that's been wound up. And we need really good evidence. So effectively a whistleblower, someone who comes forward and says, I was working on that job and I saw this happen and I know what the relationship is. I'm not asking anyone to put their neck out on the line here or to do the wrong thing. What I'm saying is that the factual situation that I need or any other lawyer would need to be able to go through and make a good test case out of this is to have really good facts, really good evidence to get rid of all the clutter so that you can get to the heart of the matter, which is the fiduciary issue, and turn around and say, righto, as far as the developer is concerned, as a fiduciary of that incipient to be formed body corporate, they have taken a financial benefit to themselves because they haven't had to pay for consultancy services by binding that body corporate to that body corporate manager for that first initial term. So that's the first test case I'm after. The second one is money for nothing. It relates back to insurance premiums. So what I'm looking for here is a larger community title scheme where they've got expensive insurance premiums. Preferably they've been paying those expensive premiums for sort of, 3, 4, 5, 6 years through the same strata manager who has given them little or no disclosure about the commission arrangements or the alternatives. And in those schemes, there's been very few claims, okay? Very few claims. So there's this big wad of money being paid, but there's actually not that much work being done. Now, I know there's a few people screaming at me saying, have you got any idea what we do to go get insurance quotes and all the rest of it? Yes, I'm aware of the magic book of spells that my friend and colleague, Nicole from Deakin prepared in the Deakin report, and we'll come back to that in a minute. But as soon as anyone mentions that to me, I say, are you seriously doing all 47 of those things? And if so, have you recorded the time that you spent doing all 47 of those things? Can you justify that 15 to 20% in those circumstances? And that's the reason I'm looking for that test case, because there are, I suspect, out of all the strata schemes in Australia, that there are some instances where there's been big wads of money paid for commission over a long period of time, where very little work has been done. And the final one is kickbacks for me. So this is outright commissions being paid to body corporate managers, strata managing agents, on top of maintenance contracts, legal contracts, things like that. I have had a colleague call me and say, I just had a call from a strata managing agent, body corporate manager, who said, I want to refer you this job from this body corporate, but you need to pay me 15% commission on top of whatever your legal fees are. Right? That was the deal. So it is out there. So that's the sort of thing I'm looking for as well. Facts are really important because I can't go, neither I nor anyone else can just go and assert these things in court without solid evidence. So a whistleblower, I'm after a level of evidence similar to our good friend Donald Trump in relation to his recorded phone calls, in relation to the secure documents, knowing that he was doing the wrong thing. That's the sort of level of proof that we need to be able to go and run one of these, because you want to run it properly so that you get a good decision reasoned, a good decision based on good facts and good evidence that can then help push standards forward. Okay. So questions. Hopefully I haven't burned all the time, Nikki, and we've got plenty of time for questions. I do have answers to a lot of them already that people have submitted. So I'm happy to handle those in whatever order you like.
Thank you so much. Lots of things to talk about there. I really like the fact that you brought up the horizontal integration, because that's something that I really wanted to touch on in the Insurance Commission session that we had, and we just ran out of time again on that. So I'm really glad that you mentioned that, and hopefully we can continue that conversation at some point as well. Yeah, I feel like you that there are so many strata managers out there trying to do the right thing, and it's just not a level playing field, I would say, at the moment. It's really hard to talk to committees about these things and get a level of understanding from them. Would you agree with that?
Absolutely. The first port of call is awareness. Second port of call is talking about it. And the third port of call is then, working out a resolution. You've got wonderful stakeholder representatives in the form of SCA. And it's just a matter of putting it forward and saying, we need to address this. If we're going to move on as a profession, we need to address this. Okay. And how do we address it? Does that mean that we rewrite our contract? I mean, in one of the answers to the questions that I've pre-prepared, as a board member of the Australian College of Strata Lawyers, I'm happy to go to the board and say, should we prepare a draft strata managing agent body corporate management agreement for each state, which is fair from a consumer terms point of view and has adequate disclosure provisions in it for these sorts of things to cover off on these sort of issues, okay? Because I appreciate that there's been a lot of work done over the years for the standard terms agreements that have been prepared by SCA for use by their members, but unfortunately, I think they don't measure up.
Okay, all right. Well, that's that's an interesting conversation as well to have. Can a strata manager decide not to receive commissions and add an hourly fee for the renewal of insurance claims, etc., to the contract appointment? Is this legal?
Yes, and in my view, it's the best answer. It should be done with consent as a joint amendment to an existing contract, or alternatively, the next time you do your contract. I mean, if you hark back to the insurance presentation that we did last week before. It's all been a blur. There were a few comments about be careful what you wish for, right? Now, what be careful what you wish for was all about was, and this is, you got to unpack it a little bit. With all due respect, and again, I'm talking about the people who, are either uninformed or doing the wrong thing. It is clear that large insurance commissions, where not much work is being done for the commission, is subsidising smaller insurance commissions where a lot of work is being done. So you might have a 10 lot scheme that is not paying very much. You might have a 100 lot scheme that is paying a bucket. And when someone says, be careful what you wish for, what they actually mean is, well, we're going to have to take that subsidy away. In Queensland, that's a breach of the code of conduct for body corporate managers, because I think the very first duty is act in the best interest of the body corporate. So if you're charging more, or one body corporate under your watch is being charged more for insurance in terms of the commission to you, and you're using that to pay for services being consumed by another body corporate, oh my God, my head explodes when I hear that, right? And yet 2 or 3 people in that presentation said, be careful what you wish for. What do I wish for? User pays. Let the person who is consuming the services pay a fair rate for that. And the only reason it's all being done that way at the moment is, I think it's laziness, lack of awareness. It suits people because they get to keep the money. I mean, when I first started practice as a lawyer, there was a little blue book of conveyancing charges, and it was based on the value of the property. So I could charge $1,500, and that was a lot 25 years ago, for a property that was worth over $1 million. That thing was already a relic by the time I came in. You imagine the backlash that we would get if I charged a fixed percentage. It's craziness. It's absolute craziness.
Okay, so under the proposal of paying a user pays model, smaller buildings will end up paying more in the long run.
And they should. And they should. I mean, sorry, wake up. All right, wake up. It's unfortunate that that's the case, but There is no moral or legal argument that I have heard that justifies someone living in a 40-lot scheme subsidising a body corporate manager's work for someone who lives in a duplex. If someone can give me that answer, I'll have, hey, I'm an entirely rational human being. I'll accept it and I'll change my view. I challenge the audience. Please give me that. Show me why that's right. What it is a wealth transfer. And unless you're a government, you shouldn't be engaging in a wealth transfer, let alone one that is undisclosed.
Okay. Okay, the next one, can we please include brokers and anyone else receiving a benefit within the discussion of disclosure? And that's a point that when we talk about insurance commissions, there's been a lot of discussion around the strata managers disclosing their commissions, but not as much talk around the brokers' end of disclosing commissions.
Yeah, look, I understand this, but it's also a case of, hey, look, they're doing the wrong thing, so it's not as bad, me doing the wrong thing. It's a bit weak. You know, yes, I think brokers are in the same position. On insurance commissions, brokers are more likely to fit into that category of the whole relationship is based on us receiving a commission, okay? Remember how I was talking about the alliance case and all that sort of stuff? That fits into that category more than strata managers do, all right? Because the whole relationship is based on that financial arrangement. Now, does that mean that I think that the best way to remunerate brokers is commissions based on a fixed percentage? Hell no. Hell no. That's just lazy and stupid. You know, I shouldn't say it, but it's almost criminal from my point of view, because there is just no relationship between the amount of work that's being done and the amount of money that you receive. And once those two things are different, you end up in a situation where the perception of your sector, you know, it's just tainted.
And we did have some comments come through from strata managers that said, we'd be happy to give up commissions because we do more work during the year than we get paid for the commission that we charge at the beginning of the year. So, I mean, that's another argument as well, if it is on a user pay system.
Look, I'm not one of these sort of 5-star, high-octane, supercharged capitalists, right? That's not my take on life. But this is a market distortion, if you want to use that terminology. And unless or until it's removed, you're not going to get a properly functioning market. There's too many smoke and mirrors. And because of that distorting effect, people are looking for profits in other areas. And that's causing a problem. I mean, if there's this perception, you know, you put 3 or even 2 strata managing agent competitions proposals up in front of the committee, you know, they all go, they look for the headline rate and they go, they're cheaper, let's go with them.
That's it.
Oh my God. No wonder there's a problem, all right? Because there is an inadequate engagement with the issue. Now, look, I'm going to sound like I'm touting for business for the entire legal profession. But if you're a, you know, 40, 50, 100-lot scheme and you're looking at changing your strata manager, why the hell aren't you engaging a lawyer in advance to actually go over the terms of the contract and try and look at a few of these things? Or indeed, go to the law firm and say, you go and get a couple of proposals for us and give us a review. I mean, bodies corporate do that when they're paying $1 million for a painting or maintenance contract, or even $100,000 when they're doing it for a painting and maintenance contract. You know, why not?
Good point. Could Michael provide further clarification regarding his comments last week that strata managers have a fiduciary duty and draw reference to the Real Estate Services Council versus a line strata management case? So I'm not going to read it out. Yeah, I won't read it out, Michael. I'll let you explain it because you did touch on it in the presentation. And what the statements in this matter apply?
Yeah, this is the alliance case. I was laughing last night when I saw this question arrive because I was waiting for it to arrive. And basically in the alliance case, you had a strata manager who had done some disclosure of commissions, and there was a range of different types of disclosure. The Real Estate Agents Board took him to task. It ended up going to the New South Wales Supreme Court. The Supreme Court turns around and says, yes, it's a fiduciary relationship, so tick in that box. Was there adequate disclosure or inadequate disclosure? Some of the disclosure was inadequate, some of it was adequate, and there was a lovely one juicy paragraph where I think it's Justice Meagher turns around and says, well, look, if the relationship is founded on the basis that you are going to be receiving commission, and that is reflected in your contract, the contract displaces the law of fiduciaries and you're A-OK. Now, a couple of things I'd say about that. You need to understand the whole case and not just one paragraph. Second thing you need to do is to understand that it was, I think that's around about when we had Nokia flip phones, 94. I think we still had the Trade Practices Act in place at that stage rather than the Consumer Code. Consumer law has moved on, people. All right. Consumer law has moved on. And with it, your obligations have moved on. Relying on a 30-year-old case when you are doing lip service disclosure is not adequate. It's not adequate. And if you take the view that it's in my contract, so it's okay, then I tell you now, one of the things I'll go look at, and when I say I, it's a collective I. Members of my profession who are confronted with frustrated and angry bodies corporate who believe that they have been ripped off, we will go looking, and that's our job. We're very intelligent, creative people. We will go looking in other areas. I'd be looking in the consumer law for one place. Unfair terms. How can I knock over that contract? What actually happened at the time of formation of the contract? You can be fair. You can be full in your disclosure and frank and still get the job, all right? You're not necessarily going to scare people away. I mean, lawyers have been doing this for decades. That's what we do. You get a scope of works fee proposal for a litigation matter, and we'll say our estimate is between 30,000 and 100,000. And here are all the variables that go into it, all right? And we air the dirty laundry, bang, straight up. And if you fear that, okay, you fear it. But there's also a bit of there's going to be a few pioneers here. And what I'm trying to do with the paragraphs that I've provided is to give them the ammunition to really say, this is what we do. You should start to expect this from other people as well, And the people who don't have it, have a long, hard look at yourselves and ask why that is the case. And with the best of intentions, this is from the bottom of my heart, start moving in the right direction. Wean yourself off that stuff. Because this cost of living crisis, it's not going to finish tomorrow. There's going to be the heat of 1,000 sun on these things, and people are going to come looking.
Mm. And I haven't seen the giveaways that you've got for later in the session, Michael, so it's great that you've been able to provide those, but would they be able to be used in conjunction with John Trowbridge's handbook that he's put forward?
Absolutely.
Yeah, because that's a really great guide, I find.
Yeah. I've stayed away a lot from the specific sort of nitty-gritty of the insurance stuff so that John and I have some good subject matter to talk about. But I said 2 weeks ago that, in my view, John's material is excellent for the insurance side of things because he goes to that level of explaining how you get to the number. And there's also an explanation of the business model. This is how the business works, which is excellent. That's the sort of stuff where you imagine that you're in the hot seat being cross-examined by a King's counsel in front of a Supreme Court justice about your business practices. My mentors over the years, one or two of them have said that. If you're ever worried about how you practice, think about this. Imagine that you're in the witness box being cross-examined by a King's counsel in front of the Supreme Court of Queensland, and they're asking you about your business practices. Are you going to be proud or are you going to be scared?
That's in the words of my father, has always taught me that as well, Michael. So I'm really happy to hear that from you. Okay, and the question is, if you were to adopt John Trowbridge's handbook to disclose into something like insurance commissions, is that enough fully informed consent from the committees to get you through, or not?
Look, and I'm going to be careful here because this is a matter of probabilities. Most likely, yes. All right, but I can see that schemes with complex insurance needs or complicated policies that have been presented to them, anything north of the tropic might have a significant issue that needs more advice. It's really going to be horses for courses, but I think that John has pretty much nailed it for most situations, right? But that said, insurance contracts are complicated. There is a deliberate opacity to some of these arrangements, in my view. It's even though plain English is used, they're still incredibly long. There's a lack of commonly defined and used terms. It deliberately creates a lack of transparency in the market so that you can't compare apples with apples. And that's really bad, you know.
Okay, and I notice a few people are sorry that they're sort of saying that they have to go. If you're staying with us, we have still got a few things to cover, so please feel free to stay with us. But we understand if you have to leave, because I know we've gone over time. But another question that we had come through, and this does tie in with what we've been talking about. In Queensland, I'm a body corporate manager who does not engage in the practice of taking commissions. I've seen a number of instances in my time where strata managers tender based on lower strata management fees without disclosing that premiums will be higher, sometimes by 20 to 30% due to insurance commissions or other fees, which consequently make overall body corporate expenses higher. I think there are ethical concerns where a strata manager advertises a low strata management fee but relies on hidden commissions that are not disclosed upfront to offset it. Should strata managers be required to be more transparent when tendering for strata management contracts by disclosing expected charges to fees and commissions for strata buildings when they are tendering for strata management contracts?
Yes. The next question is, how do you achieve that? Look, there's a window of opportunity to try and seek amendments to our BCCM Act here in Queensland. But you know what? That's why I've asked for the test cases. That test case around money for nothing, which is taking great big whacking commissions when there's no claims or very few claims over a period of time. That's all about, like, I'll tell you now, if I get one of those, then I'm probably going to be asking for an account for profits, because then what I'm going to be after is, what are the internal expenses of that body corporate manager apropos that scheme? So then I can prove the cross-subsidization issue, right? Or, because that strata manager is either going to say, well, yeah, I kept all that profit, right? Or they're going to say, well, actually, it subsidized these other schemes. There's going to be this cascading effect. And, you know, people that are doing this, I'm coming for you. All I need is a test case, all right? So please change. Please do it properly. Please undertake full and adequate disclosure. Make sure, you know, and it's hackneyed, but imagine you're the person making the decision, okay? You can be the world's best strata manager and have the best relationship with your committee members and the best relationship with the lot owners, but you genuinely need to try and distance yourself from your own point of view about yourself and put yourself into your client's shoes and say, is this the level of information that I would like before I make a decision? You know, and I'm sorry, but there are some strata managers who load the dice. You know, they'll put up proposals that are deliberately look worse, but are actually better in real terms for the body corporate, because it's about how the money flows. And that's one of the things that John's looked at.
Well, I put a challenge out there to committees. Michael, you've put a challenge out for strata managers. I challenge committees to look into their contracts in detail, because there are strata managers out there that are trying to do the right thing and they're presenting a quote and they're discarded because of their bottom line figure that's put forward, and the committee will go for that cheaper quote, and in a lot of instances, it should have been that strata manager that you've gone for, because once you add all of the fees up, it's actually costing you more, and they might not be presented well and they're hard to find. But so I challenge committees to make that part of their job so that the good strata managers that are out there will actually shine through.
What's wrong with SCA putting out a comparison sheet like John Trowbridge has? You know, that's an interesting issue, isn't it? Because it would the process of getting to that point would be a very useful process, I think, for SCA at all levels to undertake. You know, here is something that we are releasing. I mean, SCA, it is there to represent strata managers. Okay, that's its job, and it should be unapologetic about that. But you've got to balance that against what's in the best interests of strata managers in the short term, the medium term, and the long term. All right, that's what this is all about. Short-term gain for long-term pain is not a great deal.
Definitely. Okay, now we had a question we've got that came in, and the question is from Queensland. If a body corporate manager has fiduciary responsibilities, where will that likely leave body corporate managers who engage with the developer in setting up a scheme, and as a reward for the developer are provided with a 3-year contract, including an inflated fee not subject to competitive tendering to administer the scheme? They would have never administered the body corporate, they would never have advised the body corporate of that scheme, of the developer's involvement in its establishment, management or the questionable conduct of the developer in applying accommodation module where the scheme did not qualify?
Yeah, look, this is one of the 3 categories of test case that I'm after. So that's the way you do it, is the way I categorized it. Now, I did put it through the lens of having a go at the developer, okay? Now, it's 13 years ago now, I wrote a paper that was published in a law journal about developers' fiduciary obligations. And in the process of doing the research for that, I did come across some law which was suggestive of the idea that where there's effectively a sort of a co-conspirator in the breach of fiduciary duties, i.e. the body corporate manager or strata managing agent in that situation, that you may be able to make the claim against them because they're the ones who have received that benefit, right? So look, my preliminary answer to that is that I'd be happy to look at it as well. They are an active participant in the breach. Okay, they are an active participant in the breach as far as I'm concerned. The person, though, who is really taking the most benefit is the developer, because they're the one who is walking away with a financial benefit that really should be discounted off the fees that the body corporate is paying. That's where the harm arises, yeah? If the body corporate manager is handing over a perfectly reasonable, non-inflated fee management agreement, and it stands up against any other management agreement there is, then they get a benefit from onboarding because there is retention that takes place. You know, you don't lose as many. If you get them through the front door, you might lose some, but it's a good way of keeping your business afloat, right? And I have nothing against that. That's just a business tactic. Let's go target new developments, and that's where we'll pick up most of our business. That's fine, no problem. It's about how you do it. But the person who's really benefiting from that sort of arrangement is the developer, because they're getting something for free.
Okay, well, hopefully that helps with that question. Our body corporate manager has an item D, additional fees, insurance, processing the claims and handling of queries, body corporate management hourly rate in the body corporate management agreement. And there's also an item K, special conditions in the agreement that states if the insurance commission is less than the 20% of the base premium paid by the body corporate will pay to the manager a fee being the difference between the commission received and 20% of the premium. So are these additions common practice in the industry?
Now, look, I understand that that's common in New South Wales. In fact, someone mentioned to me that sort of clause might actually be in the standard terms agreement that's out there. I can't speak to that because I don't know. I like to call those clauses, hey, you agree that I win or I win more. Would you enter into this contract with me, but you agree that I win, or I win more and you lose, or you lose more. It's pretty crappy, isn't it? And the fundamental problem that I have with that, because it's about, see, contracts, you know, a good friend and colleague of mine years ago explained to me that his view of contract law was risk allocation. It was all about allocating risks to one person or another. And the process of negotiation was about working out where someone's risk tolerance was. And when you found it, as long as it overlapped, then you're okay. You'd reach an agreement. So this is all about, you know, a superior knowledge in the hands of the body corporate manager, putting together a loaded contract that suits their interests. And I'll come back to that. And if it's prevalent, if it's part of the standard terms, then apparently there being no choice about the matter. And probably the body corporate hasn't received independent legal advice about that, or independent financial advice about whether there's a better way to do it. So there's all sorts of issues around informed consent. But let's circle back to why I think that's bad fundamentally. Well, there's perception issues for a start. And the reason that the perception issues arise are there is no relationship between a fixed percentage and the amount of work that you actually do. Okay? No relationship at all. So, you know, someone says to me, I just want to take 20%. I say, well, have you actually done a cost benefit analysis to see whether that covers the amount of work that you're doing? And people either won't have or they will have. And if they have, you know, why do we still have it? It must favor the strata manager. You know, if it didn't favor the strata manager, you'd do different stuff, wouldn't you?
And I believe that it is part of the contract in New South Wales as well. And I have seen it in Queensland contracts as well. We thank you very much for your extended time again today. That's quite a bit of time that you've put into that, and we do know how busy you are.
Thank you very much. No, it's been a pleasure. And hopefully people get a bit of value out of it. Please have a go at that information in the pledge so that you can start holding these people to account. Promote better business practices and send me some of those test cases. If you know of something that's dodgy and you can prove that it's dodgy, send it to me. That's what I love. That's what gets me out of bed in the morning, is to take those sort of cases forward and make things better. That's what motivates me.
Excellent. Thank you so much. And you mentioned that you do have some content, Michael.
One is the paper that I did in relation to developers, which helps unpack a bit of this. Obviously, the slides contain those paragraphs, which I'd love to. It would bring unalloyed joy to my heart to see those start to pop up in a few proposals, because it would really mean that there are people out there that feel the way that I do, that some of these things have to change.
Okay, excellent. All right, that sounds great. Thank you again, Michael. Thanks to our audience. These are obviously quite controversial topics that we're talking about, so we do appreciate the fact that our audience turns up and supports us in these sessions, and hopefully you're enjoying these and the next one that will come on the 24th of August. All right, thank you so much. If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.